So we are starting, and our panel is dedicated to international order and justice, which are not perfect and not always can solve the problems which arise. And currently, Ukraine is seeking justice in various international institutions. Despite the fact that conflicts occur all the time, Ukraine has to find its own way to bring to account Russian leaders who committed the crime of aggression, which is the mother crime. Anton Korynevych is the ambassador at large of the Foreign Ministry and one of the leading Ukrainian lawyers. Together with a team of like-minded people from different countries, he is looking for a way to create an international tribunal for aggression. It's my pleasure to invite Anton to give his welcome speech. The floor is yours.
Thank you so much, dear Oksana. Good morning, dear ladies and gentlemen. It's a real pleasure and honor to be present today here during this conference and during this panel. And I would like, first of all, of course, to thank the organizers of the conference, all the organizations, both civil society and governmental agencies, who made this conference possible. As part of my heart will always remain Crimea. And I'm really glad how we turned the issue of the occupation and reintegration of Crimea since 2019 to what it is now. And in particular, this conference is one of the symbols of this. And I'm glad and proud that I used to serve as President's representative in Crimea for almost 3 years. And of course, today's panel is very important due to the fact that accountability and justice is one of the key elements of how Ukraine see this world and the situation after the Russian aggression. And accountability and justice is the inherent part and one of the key pillars of the peace formula by His Excellency President of Ukraine, Mr. Volodymyr Zelensky, in particular within point 7, restoration of justice, which means that whenever we will talk about peace and whenever we will talk about the end of the war, which is caused by the Russian aggression, we need to think about accountability and justice. There may not be peace without justice. And Ukraine really, since this war of aggression started in 2014 with the temporary occupation of Crimea, Ukraine really works on all the tracks and uses each and every international mechanism and tool in order to bring Russian Federation and its citizens to accountability. Since 2014, we are in each and every possible international court where we could file applications against the Russian Federation. And of course, I'm sure that you followed the news, in particular in September from The Hague, from the hearings in the International Court of Justice on allegations of genocide case. But we see that in order to get this accountability and justice track done, in order to ensure accountability and justice, the existing international legal mechanisms and tools are not enough. And we see at least 2 important gaps, which we, with our colleagues, both from Ukraine's governmental agencies and from our foreign friends and partners, we try to close, to fulfill these accountability gaps. One of them is the absence of compensation or reparations mechanism. And that is why our colleagues, in particular in the Ministry of Justice, work hard in order to establish the fully fledged compensation mechanism, which will consist of Register of Damage, Compensation Commission, and Compensation Fund. And you know that one of these important elements is already established. The Register of Damage starts its operations in The Hague. And the second gap, which we in the Foreign Ministry and our colleagues from foreign ministries of other states work on, of course, together with the Office of the President and other governmental agencies, Prosecutor General's Office, is the accountability for the crime of aggression. We believe that this is one of the core elements of ensuring full and comprehensive accountability for all the Russian crimes committed in the territory of Ukraine. Because in our context, in the context of the Russian war against Ukraine, if it wasn't the crime of aggression, as Oksana called it, the mother crime, the primary crime, there wouldn't be any single war crime committed on our land. Because before this war of aggression, we didn't know what is a war crime before the occupation of Crimea started. So that is why we believe that ensuring accountability for the crime of aggression is really important now. And moreover, it is important because this is also the crucial moment for the international law itself for the principle of non-use of force or non-threat of force enshrined in Article 2.4 of the UN Charter, and for the very concept of the crime of aggression. Because if the crime of aggression, in this particular case, when it is recognized as aggression, in the resolutions of pretty much all the engaged international organizations, in particular the UN General Assembly resolutions, is not investigated and prosecuted, then the whole concept of non-use of force, non-threat of force, and the illegality of aggressive war would be at stake, would be questioned. And we are sure that this is not only the matter for Ukraine, and this is not only the European matter, how somebody may consider. This is really the international matter, because if we do not pursue accountability for the crime of aggression now, this crime might arise in other different regions of the world. And then any dictator might consider that he or she will not be punished for this crime, because in the case of the brutal Russian aggression, nothing happened. So that is why we believe that this is really the international character of the reaction which we need to have. And that is why we believe that for the countries outside Europe and for the countries in America, Asia, Africa, it is important also to work on this, in particular because many of them voted for UN General Assembly resolutions with the recognition of aggression. As of now, we have a core group of states which comprise now 38 states, not only European. We have some states from Central America, which is very important for us. And we gather together and try to find out the best possible way to establish a tribunal. And of course, it would be very important for us if some other states from other regions of the world join us, because then they can work with us together on this initiative. They can then try to see how to establish a special tribunal. We have already made very important first steps. One of them in particular is the establishment of the International Center for the Prosecution of the Crime of Aggression, ICPA, the first international effort for the prosecution of the crime of aggression after the Second World War, in case of real perpetration of the crime of aggression. Already now, in The Hague, 20 prosecutors from several states from the world, including 6 from Ukraine, work daily on investigation and common prosecution and coordination of investigations of the crime of aggression. And of course, we understand that common action in the United Nations will be needed also. Whether we go for the establishment of the special tribunal for the crime of aggression against Ukraine as a purely international tribunal, on the basis of Ukraine-UN agreement with relevant action by the UN General Assembly, which might request the Secretary General to enter into agreement with Ukraine. And this is a preferable format and preferable model for Ukraine. And then, of course, votes in the UN General Assembly will matter a lot, and votes not only from European states, but for the states from other regions also. Or if we decide or see that there might be some other track for the establishment of the special tribunal, endorsement and support for this tribunal in the resolutions of the UN General Assembly will be crucial. So that is why whether we choose the preferable model, which is the international model on the basis of Ukraine-UN agreement, UNJ will play the important role, or if we find some other model which will be okay for us and our international partners, the actions by General Assembly will also be very important. To close this introductory remarks, this war of aggression started in 2014 in Crimea. This crime of aggression is important for us to find the solution in order to cover the issue of investigation and prosecution of this crime. This is probably the only mechanism which might bring to responsibility all the perpetrators of the illegal attempted annexation of Crimea started in 2014. So that is why we would continue this work. This mechanism, the special tribunal, is in particular important to get the accountability and justice for Russia's illegal actions in our Ukrainian Crimea. And I'm sure that together with our international partners, we will find the solution. And of course, support from as many states as the support can be established will be really important for us. I thank you.
Thank you so much, Anton. And now we'll start our discussion. We have 6 panelists here. 2 will be online. I hope, and for here. Richard Goldstone from South Africa. He serves as the Chief Prosecutor of the International Tribunals for Yugoslavia and for Rwanda. He also is a human rights lawyer. Araik Ghazaryan from Armenia. He's a human rights attorney who specialized in the protection of human rights, including the situations during armed conflicts. Mossaad Ali Mossaad, a Sudanese lawyer, and the executive director of the African Center for Justice and Peace Studies. Leopoldo Lopez from Venezuela, a pro-democracy activist who was a political prisoner from 2014 to 2020, and also had to flee from Venezuela. Yasmin Jusudu Sharif, a lawyer who also worked as an executive secretary of the Truth and Reconciliation Commission in Sierra Leone, and Felix Maradiaga, a politician and pro-democracy activist from Nicaragua. He is a critic of Daniel Ortega dictatorship and was arrested after announcing his intention to go for the president. And now I'll invite Richard Goldstone. Do we have him online? Yes. Mr. Richard, hello. Nice to see you. The goal of the international legal order created after World War II is to stop wars and prevent them. But since then, civil wars and international conflicts had occurred all over the world, and there are wars which are going on right now. It turns that the established international order cannot cope with these challenges. What didn't work and what changes need to be made in the United Nations system? What else needs to be changed?
Well, really, firstly, thank you very much for inviting me to join you this morning. I'm getting an echo in my voice. Maybe the technical people can help me. That's better, thank you. Modern international criminal law really dates from 1996, when the UN Security Council decided that bringing justice to the victims of war would aid in bringing about peace. Accordingly, the Security Council established the International Criminal Tribunals for the former Yugoslavia and for Rwanda the following year. Now, no human institution is without its faults, but the work of the two ad hoc tribunals established by the United Nations Security Council did bring some solace and justice to many victims. In particular, the work of the tribunals proved that many serious war crimes were committed, including the crime of genocide. When we began in the former Yugoslavia, the vicious war was underway, as it is, unfortunately, in your country. But that did not deter us from investigating the commission of serious war crimes, including the crime of genocide committed by the Bosnian Serb army in Srebrenica in the middle of 1995. Those most responsible for that terrible crime, Karadzic and Mladic, are today both serving long terms of imprisonment. Similarly, some of the most senior leaders of the Rwandan genocide are now behind bars. I would stress the importance for victims of the proof of the commission of these war crimes. If you want to see physical evidence of its importance, you could visit the Genocide Memorial Museum outside Srebrenica in Bosnia and Herzegovina, and the Genocide Memorial Museum in Kigali, the capital of Rwanda. The careful proof of the fact may not bring back the victims, but what they do know is proven clearly and publicly, and the detail is there, and it makes dishonest denials of the atrocity crimes all the more difficult. I have no doubt that it is justice for the victims in Ukraine that has compelled the government of Ukraine to refer the situation in your country to the International Criminal Court. and it is now seeking an additional route, as has just been explained to us, an additional route to investigate the crime of aggression perpetrated against Ukraine by Russia. The International Criminal Court has already issued an arrest warrant against President Putin for crimes against humanity arising from the illegal transfer of hundreds of thousands of Ukrainian children to Russia. It really is a horrible crime to think about. I have no doubt that further serious charges of other war crimes will follow against leaders of the Russian Federation. Justice for victims is also the reason that even in the midst of the present war, the courts of the Ukraine are bringing to court members of the Russian army who are charged with serious war crimes committed on your territory. To its credit, your government is sending independent monitors to attend these trials in order to ensure that they are conducted in a manner that is fair to those who are accused. Turning to the crime of aggression, it's unfortunate in my view that the International Criminal Court does not have jurisdiction over the important and serious crime of aggression in the case of Ukraine. And there's been debate now for many months on how best to set up a tribunal that has such jurisdiction. I won't go into the various options, but I will deal with one problem that certainly has worried me. Head of state immunity protects President Putin from criminal charges in all domestic courts. It is only before an international court that the crime of aggression can be brought against a sitting head of state. It is for that reason alone that I have strongly supported the establishment of an international court by Ukraine in partnership with the United Nations General Assembly. That would create an international court, and in such an international court, President Putin would not be able to rely on head of state immunity. That was the way in which international criminal courts were set up for Cambodia, and in a similar way for Sierra Leone. So I hope I've explained the main purposes and goals of international criminal justice. It's very important for the victims of the serious crimes that have been committed. Thank you.
Thank you so much. But the next question will be about hostage. International humanitarian law prohibits taking civilian hostage during the armed conflicts. Russia is currently doing that. How Ukraine can deal with that? And do you know any such precedents in other conflicts, and how were they resolved?
Well, the taking of hostages is a very serious war crime. It is outlawed in Common Article 3 of the Geneva Conventions. The Geneva Conventions prohibits the taking of hostages. It is also prohibited by the 4th Geneva Convention, and it's considered a grave breach of the Geneva Conventions. In 1979, the United Nations General Assembly approved the International Convention against the taking of hostages. It was adopted on the 17th of December of 1979. The convention entered into force in 1983 and had 174 states parties as of June 2015. So you will see that there's very wide acceptance and recognition of the serious crime of hostage taking. There have been some examples of hostage taking. Hostages were taken by the Bosnian Serb army. They took, in fact, United Nations employees as hostages. Hostages were taken in Iran. The international community has always regarded with disgust the taking of innocent people and holding them as hostages. And I'm sure that this will feature before the International Criminal Court in the coming months.
Thank you so much. You just mentioned International Criminal Court, and Armenia has ratified the Rome Statute just yesterday and became a member of the International Criminal Court. Ukraine also signed this document a long time ago, but has not ratified it yet. Araik Ghazaryan is an Armenian lawyer, and so my question will be to you. Why has Armenia decided to ratify the Rome Statute right now?
Yeah, thank you. Yeah, indeed, the president signed the Ratification Act yesterday, and it was adopted by the parliament a week ago. So it's kind of Armenia is in rush, is in hurry to have this instrument. Why Armenia signed? The most important reason, or the sole reason, is to secure international protection against aggressive act of aggression or war crimes in the territory of Armenia. Because we have neighbors who often make political statements that they take a certain corridor from Armenia, which is in the territory of Armenia by force. So far, we've been in military conflicts in the last 30 years, but mostly those were outside of territory of Armenia or on the borders of Armenia. But now we are exposed to a real risk that we may be invaded or at least committed still an aggressive war, but in a very limited period of time like last year. So, most important reason is to secure international legal protection, which is also an issue, whether the legal protection would be effective in the active phase of war. It's a matter of discussion that we may discuss today, whether international legal instruments are effective or not. Anyway, Armenia has already made such decision, even though we had these very severe warnings from our so-called ally country, Russia, that I can tell you about that later.
Could you tell us what kind of discussions did you have inside the country before the ratification? What were the fears?
Well, the discourse is still ongoing, even though we've already adopted this document. Discussions, they followed between, among the legal professionals, including society. Political factors and legal factors were the matters of consideration. Among the legal matters, which must be weighed with political factors in order to decide whether they're more going to be positive or negative aspects. Among the political, of course, the Russian factor, because Russia was severely against that Armenia signs, and even a few days ago, when the parliament adopted, Dmitry Peskov, the Kremlin speaker, said that, verbally said the following: it was an extremely hostile act against Russia. So if the Kremlin speaker says that, that means the Putin says that. Anyway, so number one factor political is the Russian factor, because Russia has a military base in Armenia, and there are military personnel there who may have been prosecuted by ICC, and if they appear in the territory of Armenia, whether Armenia should arrest them and surrender them to ICC or not. And first of all, of course, it concerns to Putin. But when we started discussions, the Ukrainian war was not in place yet, so there was no charges against Putin. And then discussions were not really ongoing. But then after the Ukrainian war, when the charges were brought, now his prosecution is ongoing as Putin, the society mostly were concerned about this factor. Among the political factors, there are no other political factors, of course, or maybe also joining to international community. A democratic or progressive international community and getting more friendly countries in the world once we join this family. But there are also legal factors. I've been litigating in international courts in the last 20 years, and I had many successful decisions, but also had many reasons to be upset from international tribunals. And number one reason is the time frame. It takes very long, 10 to 15 years. All my cases that I won in the European Court of Human Rights took 9 to 10 years. The last case about armed conflict in the context of government propaganda was issued in October 6 against Azerbaijan. And that took 7 years, and I was very glad about that. Second legal factor, negative factor, that national tribunals, they limit their jurisdiction. And as you know, the ICC has two types of jurisdiction, territorial and citizenship, nationality. Armenia mostly relies on the territorial jurisdiction. And when we ratified the statute, we made only one declaration that the statute should go back to May 10, 2021. That was the first time when military operations took place in the territory of Armenia and summary executions took place, posted on the social media. The international tribunals usually limit their jurisdiction, and that also affects the possibility of having an effective remedy from international courts. And let's take the ICC. In the last 20 years, in operation since 2002, it has only 31 cases. The last statistics I took from the court webpage yesterday, only 31 cases and 10 successful judgments, 16 fugitives. So when a country decides to join this international legal framework, they have to consider the political factors against whether they're going to gain effective legal remedies, or individuals, or even the state at large is going to get effective legal remedies. Anyway, all these are behind already. We ratified this, and we are exposed now to political pressure from Russia, and we don't know whether we're going to arrest Putin or not if he arrives in Armenia, but we have to. We will have to. In 60 days, I guess tomorrow, next week, the government will send the document for deposition with the UN Secretary General. In 60 days, we'll have it in full effect. Then we'll have to bring in compliance our criminal law with the ICC, and then we'll see what happens.
What does Armenia expect from the International Criminal Court?
What do we expect? Well, first of all, to prevent possible act of aggression and to prevent possible war crimes in the territory of Armenia. That's the number one. So we are securing international security by referring to this international legal order. There are, of course, also political tools, diplomatic tools, but there are many people who are not really optimistic about having international legal tools as effective measure of protection. But we rely on everything that we think would give some possibility to protect our country.
Thank you so much. The international justice, as you say, takes very long. And the International Criminal Court began investigating genocide and other atrocities in Darfur, Sudan, almost 20 years ago. And there is still no judgment. One case was closed. Some of the suspects are at large. And the president, former president, Omar al-Bashir, despite the promise of Sudan to the International Criminal Court, was not handed over, and only one suspect is in custody right now. Are people of Sudan still waiting for justice after these 20 years? And do they still believe in it? And this question I will address to Mossaad Ali Mohamed.
Well, thank you so much, Oksana, and thank you so much for the organizers for giving us the opportunity to be on. And actually, I'd like to start from the speech, from the part of his speech that has been delivered by Anton, which is we cannot achieve sustainable peace or lasting peace, without having this question of justice and accountability addressed. And this is maybe one of the major issues that has led, to this very complicated situation in Sudan. In terms of team process, or even in terms of reaching the justice and accountability. To understand the context, it would be very crucial to give a short background about the conflict itself that has led, to these violations, and also resulted in the referral of the situation in Sudan to the International Criminal Court. In 2002, or 2001, 2002, there was a region in Sudan, the western part of Sudan, called the Darfur region. The majority of the population in this western region, they belong to the African tribes. And Sudan actually like a diverse country because it has like more than 8 neighboring countries, 4 of them like Arab countries, Libya, Egypt, Saudi Arabia from the east. And then back there we have Central African Republic, Chad, before that there was Kenya, Uganda. So it's a very big and very diverse. The political issue has a very strong presence and has led to a number of conflicts in Sudan, not only in the region of Darfur, but even the rest part of the country. Because there is exclusion, the exclusion from specific ethnic groups, from participating or from sharing the wealth and the power. And for that reason, the politicians in the Darfur region have taken up the arm against the central government in 2001, claiming to have their share in the wealth and the power. As a result, and because at the same time, the government of Sudan during that time was engaged in a war, internal war in the southern region of Sudan, so they have assigned militias called the Janjaweed militia, and majorly they are composed from the Arab tribes or from the Arab ethnic groups, and they have committed this genocide and war crimes and crimes against humanity along with the Sudanese armed forces. This situation actually has brought the attention of the international community because the number of the deaths was more than 200,000 people have been killed, 3 million people have been internally displaced, and 300,000 people have been forced to cross the border and become refugees in neighboring countries. This is besides the destructions of hundreds of villages and other crimes as well. Since Sudan was not state member to the International Criminal Court, the Security Council, the UN Security Council under Chapter 7, they have adopted a resolution by which they establish an international commission of inquiry so as to be sent to Sudan to investigate the situation, actually like fact-finding missions to identify the crimes and also to identify those who bear the greatest responsibility. And they're supposed to report back to the Security Council within 3 months. This commission or this International Commission of Inquiry was established in 2004, September 2004. By the end of, or by the beginning of 2005, they have reported back to the Security Council. And then again, the Security Council find a ground, for the referral of that case to the International Criminal Court for the second time, because also they have the jurisdiction or they have the mandate actually to refer the case. And it could be similar to what happened in Ukraine, despite the fact that in Ukraine, the referral was by the state members, more than 39 state members, they have agreed to refer the case. But actually for Sudan, they use, the power under Chapter 7 for the Security Council to refer the case to the International Court, and this has happened. And accordingly, in 2005, they have started their investigation. But the Office of the Prosecutor, but that time they didn't have access to the country because they have been denied visa to enter the country, and thus they have been relying on international organizations, UN agencies, national NGOs, to conduct part of these investigations. By interviewing witnesses, victims, collecting evidence, etc. By the end of this process, actually the ICC found that there are gross crimes against international law and specifically against the Rome Statute, which have been referred to in the report of the International Commission of Inquiry. So there was arrest warrant. The first 2 arrest warrants was in 2007, and actually it has taken like 2 years, to get the first arrest warrants. Unlike the situation, for example, in Ukraine, because there was access, to the country, and there was a collaboration from Ukraine, and even the prosecutor himself has been here, and also he has said the biggest ever investigative team that has arrived here. So maybe that's why it's like a bit faster. It has taken 2 years, to get or to issue the warrants of arrest against 2. The first one was the Minister of Interior Affairs, and the other one was the Janjaweed militias. 2 years later, in 2009, then comes the third warrant of arrest against the president himself. And also, he faced actually the same accounts of crimes against humanity, war crimes, and then later on they add the crime of genocide. 2012, and this is almost like 7 years later, there was a fourth warrant of arrest against the Minister of the National Defense. However, it has taken longer than it should be, but at the end of the day, actually, there were some progress, despite the fact that it was slow, but you can see relatively there was like a move forward. So this could be actually like a brief background about the context and the situation or the case of Darfur or Sudan.
And do people still believe in justice in Sudan after this?
Well, actually, I can't say that, there is justice right now, because, even after this 20-something years, just like 5 months ago, 15th of April, there was a new cycle of violence in Sudan. And this actually, this time, not only in Darfur, but actually it covers the entire country. And according to the Office of the Prosecutor, these crimes that have been committed since 15th of April up to date, they are amount also, to crimes against humanity and war crimes. And since the Office of the Prosecutor, they doesn't have the mandate to investigate other parts of Sudan, apart from Darfur, so they have launched their investigation in Darfur in June 2023. For the victims, actually, for the previous victims and even for the current one, it has been really very long process because they have been waiting more than 20 years, for example, for the people in Darfur to see this justice done, but that has not happened. And even within the national systems, the national judiciary system, they don't have access to justice. And simply because, first of all, there is no willingness from the side of the government itself, to move forward with this investigation. And besides that also, there is no ability as well. So willingness and ability is absent. And simply because the perpetrators, they are still there. And even the laws, still grant like blanket impunity to all the armed forces, the police, the militias, they are covered by this blanket impunity. And that's actually, it could be like impossible for the victims, to see this justice done within their country. And for that reason, actually, they are still having that hope, to see this justice one day through this International Criminal Court. It is true that there is one case among all these against these Janjaweed militias, Aliko Shep, the trial has started just 2 years ago. I think that 2020 has been surrounded to the International Court. He was captured from a neighboring country and then being transferred to the ICC custody. And the prosecutor has presented his case on the 18th of October this month. In 3 or 4 days' time, then the defense actually will launch his opening statement for his case. So this could be like the only one case, within this long period of time that has, reached to the stage of the trial. Despite the fact that actually for the victims, they think that actually this is not the real target because he's just like a Janjaweed militia, not the one who bears the greatest responsibility like the president or the Minister of Defense or the Minister of the Interior Affairs. So, however, there is still hope because they don't have any other option within their country.
As you mentioned, in March 2009, the President al-Bashir became the first sitting head of the state who was indicted by the International Criminal Court. There were 2 arrest warrants, but Sudan didn't recognize the jurisdiction of the ICC, and the Arab League and a number of countries opposed the ICC and didn't arrest al-Bashir when he visited these countries. For instance, South Africa, which is a member of ICC and has commitments before the court, also didn't arrest him. Why is it possible, and what can be done to make these countries fulfill their duties?
Well, that's really very true. As we know, the ICC or the International Criminal Court, they don't have a mechanism to implement, the arrest warrant. It always relies on the different state parties. I mean, according to international customary law, or even, according to the Rome Statute itself, for the state members to the ICC. Unfortunately, since the issuance of the arrest warrant against al-Bashir in 2009, he has made more than 74 trips, to different countries, including even some countries, state members to the ICC. For example, he has been to South Africa, as you have mentioned. He has been to Uganda. He has been to Russia before the withdrawal from the ICC in 2016. And even, to a number of Arab countries and African countries as well, and even some Islamic countries in Asia. It's true that he has not been, to any of those European countries, but however, also I think there is a weakness within the European Union system itself, in terms of collaboration with the International Criminal Court. Not directly, but indirectly. For example, in 2016, they have the EU, the EU as an entity, they have signed an agreement with al-Bashir himself, to protect the border against the migration, despite the fact that they know that actually he's wanted for the International Criminal Court and he has been charged, for crime of genocide. But despite the fact that actually they shake hands and they signed agreement, so as if they say that, okay, now we have like a deal, okay, you just protect our borders against the migration and refugees, and maybe you can just keep silent, with regard to your situation. And this actually could be even a lesson, for the Ukrainian, in terms of having, this collaboration with the different states. And here also, I think it's very important, to refer to Africa itself, since now we are speaking about the global south. The African, actually, after the indictment of al-Bashir, and specifically in 2015, after some years, they have submitted an application to the Security Council so as to withdraw the case against al-Bashir. And even in one of the African Union summit, they have discussed like a mass withdrawal from the ICC because they consider it as a Western part, or like an European stick, that aim, to destroy or to beat the African leaders. And for that reason, they have been calling for a concept or for a notion called Africa Resolution for the African problems. And even they have established an African court, just to keep some distance, with this Western tool. So this also could be maybe like a need for Ukraine, because now Putin has a strong presence in Africa. And probably he would jump to one of these countries or another. So I think bilateral conversation with these African countries, especially, those who have signed or state party to the Rome Convention or the ICC, so as to fulfill their obligation with this regard. The US itself, also that actually it has been advocating for this international justice, but when it comes, to the International Criminal Court, actually they have a very cloudly status, and that's why the Pentagon said that, despite actually the State Department, they said that they will fully collaborate, with this case of Ukraine. But the Pentagon, they say that they would not share any intelligence about war crimes with the court. So also this is need, for example, to reshape, our strategies as Ukrainian to deal with these international stakeholders and the states.
Thank you. As I understand, Richard wants to comment on this Sudan situation. Could you please turn on?
That it's important to stress the effect of a sitting head of state of having an international warrant of arrest against them. It's true, President al-Bashir visited some African states, and I'm ashamed to say and embarrassed that one of them was South Africa. The African Union, I think, greeted with shock the very idea that a head of state in Africa could be issued with a warrant of arrest. And African states, generally speaking, were shocked and against the idea of one of their own heads of state being subject to a warrant of arrest. the South African government, when al-Bashir visited South Africa to attend a meeting, a high-level meeting of heads of state of the African Union, the South African government tried to find excuses for not arresting al-Bashir, and when the matter was brought urgently to our courts, al-Bashir was ignominiously and secretly sent out of the country from an airbase outside our capital, Pretoria. So it wasn't a very pleasant experience either for him or for the South African government. Our highest courts then made it clear that the arrest warrant should have been executed, that the South African government was in violation of our own South African law in not arresting al-Bashir. And that's why when the case of President Putin came up earlier this year, when he was invited to attend a meeting of the BRICS heads of state in South Africa, the South African government realized that it would be breaking in violation of its own laws if he wasn't arrested when he came to South Africa. And for that reason, I've no doubt it was for that reason that he was persuaded not to come to South Africa and be represented by his foreign minister. The point I want to make is that it's very difficult for a head of state in the modern world to operate efficiently if they're subject to a warrant of arrest. Now, I'm happy to say in 124 countries, and it's very good news about Armenia having ratified the Rome Statute. But it means that certainly President Putin should anticipate that he's liable to be arrested if he visits any one of those 124 countries, and that's a very severe, already a severe effect that it has on heads of state. So thank you. I just wanted to make that further input.
Thank you so much for your remark. Another country that has own experience of interacting with International Criminal Court is Venezuela. And in 2014 and 2017, there were protests there against the current President Maduro and his subordinates. The protests resulted in the illegal persecution, detentions, torture, and crimes. And Leopoldo Lopez was a political prisoner and has had to flee from Venezuela. Could you please tell us more about the history of relations with the International Criminal Court and what is going on now?
Thank you very much. I would like to start by saying that I'm very honored to be here, that we stand with Ukraine, that we hope for the victory of Ukraine, and that the victory of Ukraine will also have a great influence in a faraway country where I'm from, Venezuela. So I'm very honored for the invitation, and we really hope that this conflict ends soon with the victory of Ukraine. As you mentioned, in Venezuela, we did not know about the International Criminal Court until very recently. In the year 2014, in February of 2014, when Maidan was full of people also seeking for freedom, democracy, human rights, in my country, Venezuela, we called for protest against the dictatorship of Nicolás Maduro. Tens of thousands of people went to the street all over Venezuela, and that's what took me to prison, where I spent the next 7 years, 4 of them in a military prison in Ramo Verde, then in house arrest, from where I escaped, and then I was at the Spanish embassy. In the year 2015, I remember having a conversation with my lawyer about the International Criminal Court. It was a moonshot. It was far away, the possibility of having the International Criminal Court take the case of Venezuela. But we started by filing one case, and then another case, and then we started to engage with human rights organizations that started to file more cases against the dictatorship of Nicolás Maduro that has been responsible for detaining, torturing, and killing people that have been against him. That was many years ago, almost 10 years ago, and today Nicolás Maduro is also a sitting president that is undergoing a criminal investigation by the International Criminal Court for committing crimes against humanity. The investigation has been ratified last week by the International Criminal Court, and it's ongoing. And we hope that the information that has been presented by the victims ends up in a case that ratifies the fact that Nicolás Maduro has committed crimes against humanity. In the case of Venezuela, there were more than 8,000 cases presented at the International Criminal Court last March. The organizations of human rights and different victims were able to present concrete cases that have been filed against the dictatorship of Nicolás Maduro and all of the line of command that has committed these crimes. Maduro has been attempting to undermine the investigation. The prosecutor has been in Venezuela 2 times. Fortunately, the ICC has ratified the commitment to continue with this investigation. But I believe that the fact that there is an investigation represents a hope for many people. And I understand that this is a distant hope, with time being long many times, with time being something that the victims seeking for justice, when you say it's going to take 5 years, maybe 10 years, but this is the only way that we can have justice in our country. There are no courts, there is no independence, and the only hope for justice that we have is through the international system, and in this case, with the International Criminal Court. So we understand that this is a process that requires the collaboration of many actors, primarily the team of the prosecutor and the institution of the ICC. But I want to also ratify the importance of the human rights organizations that have been working tirelessly with discipline and with great professionalism in filing each one of the individual cases. Because as we know, human rights violations are individual, require a single concrete cases with concrete proof, with evidence. And we have seen many organizations, many human rights lawyers that have been working for many years now in order to present to the ICC the reality of what has happened in our country. The case of Venezuela is not a case of war. It's not a case of an invasion. It's also not a case of an open civil war, but it's the case of the regime attacking its own people. It's a case of those in power committing crimes against their own people. And this is something that we also believe is very important for the individuals, for the communities, and for the countries that don't have justice in their country to have an alternative with the international system.
Ara, you wanted to add something?
Very short comment. What shall change the behavior of the state? Yes, sometimes we need to wait until the final outcome in the international court, but quite often, in the middle of the proceedings, the state starts to change its behavior. I've noticed that from my own case. I've been litigating with a respondent state for 20 years, and in filing consistently cases, even if you still have a long way to go, but in the middle of the proceedings, when you do that consistently, the state starts changing its behavior inside the country or in the international arena. So the fact that you filed 8,000 cases, that already may change, I think, from my own perspectives, the state's behavior inside the country. So it's not, when we're saying that takes 10 to 15 years, that's true. But it's very important to file the case, evidence collection, commencement of prosecution. It may also affect the state's behavior.
I think it does, and I want to tell you an anecdote. When I was in prison, I remember talking to the director of the prison and to my guards, and I told them, you are violating not only my human rights, but the rights of the other prisoners. And the answer that I am sure is very common in autocratic regimes was, I am following orders. I am anonymous. nobody knows who I am. And I said, but you have to be sure that our lawyers and the human rights organizations are going to make sure that they know who you are. Now, after the investigations, the names of the line of command from the president to those executing the crimes against the people are known. And I do believe that that changes the behavior, because now they know that they cannot hide in anonymity forever, that there are investigations and that their names could be part of an international organization. Unfortunately, dictators, autocrats, violators of human rights always find people willing to commit the crimes with them, because they will always give something to those people willing to commit the crime for them to make that choice. However, I believe that this is an important deterrent institutionally, and I think that they can also change behavior. Unfortunately, I'm sorry, they change behavior in the facade, in the appearance, but not in the real commitment to respect human rights and the rule of law.
Yeah, so my follow-up question is, can you see, like, when the investigation resumed, it happened in summer, did the authority change their behavior towards the people, the opposition?
I said they changed appearance. So last week, the prosecutor of Venezuela went to the UN Human Rights Council, and he was confronting the fact-finding mission. And it was very it was very obvious to everybody there that he was not defending the law, he was not defending human rights, he was not defending the rule of law, he was defending the regime. And it was very clear that they are interested in changing the narrative, but not the way to respect the human rights of the Venezuelan people.
Thank you. Our next speaker had to be from Sierra Leone, and we had to talk about the special court for Sierra Leone, but unfortunately, because of technical problems, we cannot contact her. So probably we'll proceed to our next panelist. And as experience has shown, human rights are most often violated in authoritarian countries, and we could see it from Venezuela also. Now we can witness the confrontation between democracies and dictatorships. Felix Maradiaga, a politician and pro-democracy activist, also is a victim of dictatorship in Nicaragua. And my next question will be to you. If you look at the voting in the United Nations General Assembly, it is obvious that the current government of Nicaragua supports Russia. What can be made in order for Nicaragua to change its position and to take the side of Ukraine?
Thank you so much. I'm also very honored to be here. Felix Maradiaga from Nicaragua, a country in Central America that, as you may know, based on very quantitative standards, it's the country that supports Russia the most. So if you go globally and you looked at the UN voting, not even Venezuela, for example, just to compare, nor even Cuba during the recent CELAC meeting, the meeting between the Latin American countries and the EU, where when they discussed the resolution, Nicaragua was the only country that didn't support the resolution because it lacked sufficient language to support Russia. Before going into your question, I'd like to give a little bit of context about the country where I come from and why reform at the UN it's fundamental. Nicaragua is a country that suffered a civil war during the 1980s, during the Sandinista revolution, which was fully supported by the then Soviet Union. The Sandinistas came back into power through Daniel Ortega once again in 2007, using the mechanisms of democracy. And then we have, I would say, the first lesson learned. Could you imagine transition in Venezuela? For example, And after a democratic transition of, let's say, 16 or 15 years, Maduro coming back into power using the same democratic rules. That's what happened in Nicaragua. There wasn't accountability for the crimes against humanity that the Sandinistas committed in the 1980s. So the first point that I wanted to make is that in order for robust democracies to thrive, accountability is important in order to prevent these violators of human rights to actually come back into power as it happened in Nicaragua. Eventually, Ortega became, once again, a dictator. In 2018, a massive protest happened in the streets, and the Nicaragua Sandinista police openly shoot against the protesters. Within 3 months, over 350 people were killed, based on official accounts of the United Nations missions to Nicaragua. Over 1,200 political prisoners. Years later, we see that Nicaragua has become, once again, officially, and this is a data that very few people know, the most closed country in the world, more than North Korea. So we are the only country that has expelled every single UN agency, no single UN agency present, has confiscated and shut down the Red Cross, has shut down 3,400 institutions, including all private universities, Catholic churches, entire dioceses, has put into prison 13 religious leaders, including the most important bishop in the country, who has been sentenced to 26 years in prison for giving a homily in his church calling for justice. It is a country that has expelled most EU ambassadors, and once he has done that, he has opened new embassies, for example, in North Korea. And I can give you more and more things that will be very shocking to you. And why has that happened? Precisely because it has full support of Russia and China. On September 5, 2018, I was able to give my testimony at the UN Security Council in New York, and we presented some of these facts before things got even more complicated. Precisely because of my presentation at the UN and also the European Parliament, I was sentenced to 13 years in prison. I spent 2 years in prison, not because of extraordinary international support to get me out of that. Now, directly to your question, what can be done to change that? Through diplomacy, the answer is no. And why no? Well, because what I will call the club hypothesis of the club premise does not work. What do I mean by the club premise? The UN, the Organization of American States, and many international institutions were created under the same premise that we participate in a club. The premise is that we want to be part of that club. And if you do not keep your behavior in that club, you'll be kicked out. But the thing is that these dictatorships do not want to be part of the club of democracies. They want to take advantage of this club of democracies. And these are what I will label dictatorships 2.0. These are autocratic regimes that play by the rules of democracy only in a facade. But in reality, they are tyrannies. And I can elaborate more on that particular point.
Yes, please.
Well, the only thing to counterbalance that is precisely through an ecosystem of democracies. And people like Leopoldo, for example, and many others, Gary Kasparov, has come with this, I think, extraordinary idea, the World Liberty Congress, which is precisely an ecosystem of like-minded, not only individuals, but institutions that will work together to counterbalance what dictators are doing. So the torture in Venezuela or in Nicaragua is trained by the same guy that it's doing crimes against humanity in Russia, for example. And I share an anecdote for some of you who were not in my panel yesterday. I was saying that 6 months ago, I was in a very extreme, inhumane prison. For example, just to give you some points, I didn't have drinking water on my cell. My family had to come every single day with a daily quota of water for me to drink. And they made families wait for 3 or 4 hours to deliver 1 or 2 bottles of water per day. I never had any reading material, not even a Bible, no writing materials, no light, no sunlight, no access to communicate with anyone. The guards were not allowed to speak with me, and I spent several months without even using words. And the only opportunity to communicate was during interrogations. And through that interrogation, I learned that Russia had done a full-scale invasion of Ukraine. And I could see the happiness in this officer in a distant country called Nicaragua. And I said, why are you so happy with the invasion? And he said, well, because I was trained in Russia. I speak Russian. And he started making fun of my US education. See, so my point about this is that the ecosystem of dictators also is well beyond propaganda. Sometimes we think it's only Russian propaganda. No, it's training. They're training all these people in intelligence measures. They're training in tortured methods. They're training perpetrators at the grassroots in how to persecute civil society, but we're not doing the same. And I'll use a very concrete example. Agencies such as the United States Development Agency, for example, to mention one, but I can give many other examples, have trouble when their activists were very political. So international development agencies are quite comfortable sponsoring human rights and civil society movements, which is perfect. I don't have anything against that. But the line between a pro-democracy political movement and a human rights defender when tackling these dictators is very thin. So when you become a political activist, you basically are almost alone in terms of financing, in terms of international support. I'll give a concrete example. I'm currently stateless. The regime in Nicaragua has deprived me of my nationality. They actually reformed the constitution after they expelled me from Nicaragua and put me in chains into a plane and sent me to the United States. When I landed in the US, I learned that I didn't have a nationality. And the international community doesn't know how to deal with that. Getting a passport, traveling is very, very complicated. And it's not only my case. There are only in Nicaragua 316 people in that same condition, but because some of them are political activists, they fall into a different category. It's not a violation against a human rights defender. So who defends the defenders? How do we finance political movements that are pro-freedom and pro-democracy? So we require a new international approach in terms of sponsoring pro-democracy movements. Why? Because Iran, because China and Russia are doing exactly the same with the bad guys. But we need to work with intellectuals, and that's what I mean with the ecosystem of democracies. We need to work with activists, with women movement, youth movements. We need to work with parliamentarians who are like-minded in terms of promoting new legislations. Now, concretely in terms of the international legal system, one of the big problems is not only what I just mentioned, the club mentality that is not working, but it's also that sub-regional entities are also not working. So if you go to the UN, as it happened in the Nicaraguan case, they say that based on UN regulation, you had to take your cases at the sub-regional level. But the sub-regional level is completely hijacked by these regimes. And that is something that I think that requires the utmost work.
Thank you. If you compare the attitude of the authorities to the respect to human rights and to the respect of international law, can you see any trend?
Definitely, there are many, many trends. And one of the things that we are seeing in the Latin American case, for example, is that, to give an example that I think that is very close to this part of the world, is that when Putin, for example, started to create laws many, even decades ago, for example, the foreign agent law, to give one example, to when he developed laws against cybercrime to regulate the internet, when he created laws to regulate civil society, many regimes around the world actually did a copy and paste on that particular law. So what we're seeing at the domestic level is that these dictatorships are also coordinating themselves in trying to give a legal platform to their attitudes. So the classical mentality of dictatorship, as we used to see it in the 60s or the 70s, we would expect a dictator to be on a military tank and a military fatigue and or a military junta ruling a country. What they're doing right now, and Russia has become very sophisticated in that, is to give also a legal facade to their procedures. And if we want to counterbalance that, we also need to make to achieve reform at the international level. One of some of those reforms that I think are fundamental. First, the UN Security Council must be reformed. It's completely unacceptable that a perpetrator of crimes against humanity, such as Russia, has veto power. That's immoral, it's unethical, and it's an insult to the victims, not only to the victims of that Russia has created inside Ukraine, but to the victims that Russia has created enormous suffering around the world. Number two, the UN Human Rights Council is a shame. It's unacceptable that countries such as Cuba, to mention just one example, Eritrea, and many others are part of the UN Human Rights Council. And the country that is reviewed the most in terms of resolutions and in special reviews is actually Israel, for example. So they're biased reviews, and the structure is completely a shame. So those are the kind of tasks that the ecosystem of democracies can tackle if we work together. It's something that requires not only governments. I think that it's very important, of course, to work with governments, but we need civil society, academia, activists, and even the organized religious community. Because one of the things that these dictators are doing as part of their mechanism is not only using the law, not only using traditional mechanisms of torture, not only using propaganda and intelligence, they're actually using mass religious propaganda as well. And it's a very well-designed plan. It's taking some of the things, I know that we're running out of time, but I don't want to go into many details, but just a concrete example. Things that we saw in China in the 1950s were replicated in Cuba in 1962. For example, creating an official government agency that actually approves churches that are legalized to operate. Now we're seeing that in Nicaragua, for example, and around the world. So this requires an organized effort as well from religious institutions working together with civil society. In order to conclude, this requires, once again, reform for cooperation agencies. Because with religious institutions, it happens the same with political parties. As someone who has devoted part of my life working with international cooperation, I can tell you from the inside that when there's a panel who's reviewing a grant, for example, and you see a grant request from someone that is a political activist, it might be a brilliant, well-written document, but it's political, so we'll just put that aside. Another request, grant request from a faith-based organization is also seen with suspicion. So that requires a reform of the mentality of international cooperation that wants to develop robust, pro-democracy, pro-freedom institutions. We need to work with political parties, with religious institutions, with lawyers, with human rights defenders around the world.
Thank you very much. And now we are coming to the end of our panel. So I would like to invite Anton Korynevych for closing remarks. And then probably we'll have some time for your questions, so please prepare them. I'm sure our guests will be happy to answer you.
Thank you so much, Oksana. Again, a pleasure and honor to be present today on this conference, and I would like to reiterate once again our words of gratitude to the organizers for having this important discussion and for really gathering so many bright minds from different countries, from different regions, talking about the same issues. Because I think that the things which should be common to all of us, notwithstanding the fact who represents which country, is that the illegal attempted annexation and occupation of Crimea was and is a grave breach of international legal order in the 21st century. Nobody could have believed that in 2014, in particular the heart of Europe, the attempted annexation might happen, and it might have consequences of grave human rights abuses, war crimes, and crimes against humanity. And the same is also the issue of accountability and justice for the situation in Ukraine and for all the consequences of the Russian aggression against Ukraine. So that this is a concern for the international legal order as a whole, because again, this is a grave breach of the United Nations Charter of the principle of non-use of force and non-threat of force. And it is really a very important moment for the very concept of the illegality of aggressive war to have the force and for us all to react to this aggressive war, to establish the relevant accountability mechanisms which would be able to do the job. Again, it is really important for us, for Ukraine, that people in this room and in many countries understand that our work in order to get the accountability for the crime of aggression against Ukraine done is not a work which is done in order to impede or hamper or interfere within the work of the International Criminal Court. About a lot of speakers talked today. Ukraine does actively cooperate with the ICC. We have very active and effective relations. We amended our criminal procedure code, which now includes a separate chapter on the cooperation with the ICC. We established an office of the ICC in Kyiv some time ago. And of course, we do value the arrest warrants for Vladimir Putin and Maria Lvova-Belova for alleged war crime of illegal transfer and deportation of children. And we hope to see these orders of arrest from the ICC more. But we do understand that that important gap which still exists, the gap in the issue of ensuring accountability for the crime of aggression against Ukraine, must be closed, not only for the sake of Ukraine, but again for the sake of international legal order. And of course, some speakers talked about United Nations Security Council and the need to reform of it. Of course, the ideal way to establish such a tribunal would be through United Nations Security Council, as it was the case in the tribunals where Richard Goldstone worked, for example. But we cannot do this in this particular moment of time due to the Russian position in the United Nations Security Council. So that is why we try to develop other options which might bring us to the realization and implementation of our goal. And that is why the support from different countries, from different regions, different cultures is really important for us, because we believe that this is not only important and the story of Ukraine and our fight for accountability and justice. This is really the kind of a response from international community. So that is why we really hope that we would have more countries from, not only from Europe in our core group, and we hope that the number of participating states will grow. And we hope that when the issue will be listened to in the United Nations General Assembly, we will have the support from different regions, different countries, because again, this is all for the sake of international law, and this is all for the sake of democracy, human rights, and freedom. And again, we heard today very important messages that if the crimes, the serious, the gravest crimes are taking place, and they do not face accountability and justice, like gravest crimes of Soviet regime in Ukraine and in other European states, like Holodomor, for instance, and others, then the regime considers that it can do everything. I think that we should all work for the regime to understand that it will be responsible for everything under the law. Thank you.
Thank you very much. Do you have questions? Yes, please.
Thank you so much. Thank you so much for the great discussion. It was really insightful and meaningful. But I would like to come back to the headline of our discussion. It's a new international legal order, because I assume everybody could admit that the legal, international order that we have now is not perfect. It's actually very hard to hold somebody, especially like high-level politicians, accountable. And we have only one example with Charles Taylor, as already mentioned. And from this regard, I'm really wondering, so what is your perspective? Because thank you, Felix, you a little bit touched this question, saying that probably you as a politician can like move like from this direction. Yes, so probably it can be a couple layers or couple, I don't know, like ways how it should be done. But I'm really wondering, like, I would like to hear what should happen finally that world react. Because we already have war in Ukraine, we have multiply war crimes here, and Armenia, Azerbaijan, so everything like so mixed already. But, and there is like some notion, that only after real Third World War somebody could change. Do we really need to wait to that point, or we can do something now? Thank you.
Thank you so much. Who will answer? Yes, please.
Well, when we speak about whether international legal order is effective or not, we need to anticipate two premises. One is the compilation of laws or the norms, and the second is enforcement. So the first one, I guess everything's fine with that. There are sufficient number and quality of norms, frameworks for prevention of crimes, international crimes. But what we lack is the enforcement, and is enforcement mostly under discretion of the states or the state sovereignty, because the states are sovereign. That's the basic rule of international law. ICC doesn't have its own police. ICJ doesn't have its own framework for enforcement. ICJ takes decisions, states do not follow these decisions. So perhaps we need to think more about enforcement, about limitation of the state's sovereign power in favor of international law or international some kind of a power. Again, let's think about these two premises, and I think the problem is with enforcement, that we need to think about how to make it stronger, effective, etc.
Thank you. Anyone wants to add? So we proceed to another question.
Thank you. Just a follow-up to the issue of ICC. And as we say that they don't have their own police to actually enforce arrests, the question also comes in terms of the independence of ICC. You find that the local laws gives the sitting presidents immunity, but the ICC has overall a complementary role. In the case of Kenya, we have a case where the current prosecutor was a legal counsel of the sitting president. In that case, how do you prosecute your case?
Who will answer? Maybe Richard?
Well, I think this is an important point. If the ICC, the International Criminal Court, is to succeed, it has to be seen as a completely independent body, and it is. The Assembly of States Parties have gone to great lengths in more recent years to ensure that the election of judges is done on a fair and appropriate manner, and that appropriate people are appointed. The prosecutor's independence is recognized certainly by the other organs of the ICC, and indeed by the United Nations and the international community. But if any country, or in respect of any international court, if there isn't complete independence and trust in independence, then justice will not be served, and it will not really influence the events, and will certainly, importantly, it will not bring any benefits to the victims. And it's the victims who are the subject matter of justice, whether domestic or international. And what we all have in common on this panel is the recognition of the interests of victims, and how those interests can only be furthered by recognition and enforcement of the rule of law and international law. Thank you.
Thank you so much. We have time for 2 more questions.
Good afternoon, Igor Berlyan, analyst Detector Media. I have a question about the reform of international law, because actually all current norms of international law, they were established and formed after the Second World War. And back then the world was not as what we have now. And are there any plans in Ukraine or international partners to reform the whole international law system?
Could answer such tough question? Richard, maybe you?
Well, of course, I think for many of us in this room, it is obvious that contemporary international law, which was built after the Second World War, cannot really respond to the challenges which we face now. But it is a really, I would say, systemic question, which I think cannot be asked and cannot be answered within a minute here, because this international law after 1945 produced some good results, which, for instance, are the Geneva Conventions on protection of the victims of war. Whether we may say that we may secure the ratification by some international treaty by all the states today, if we create this treaty tomorrow. So I think this is a really important and not an easy discussion. But of course, the changes should be done and amendments should be done. And in particular, I think that the very situation on which we as colleagues work, in particular on this issue of ensuring accountability for the crime of aggression against Ukraine, might show us how this issue of changes and amendments is being, tackled by international community and comprehended by international community, because this is something which hasn't been done since 1945. So let's see, in particular, in this one instance, how we can think about the greater things being reformed.
Yes, please add.
Let me comment to your question by one example. European Court of Human Rights has one very bad case law by saying that Convention of Human Rights should not be applicable in the active phase of war. That decision was taken a few years ago. That's very disappointing. And I lost my cases of property damage during active phase of war because that's what the European Court says. Can we change that? By individual applications, probably no. By interstate applications, probably no. But maybe through political window, states may reform this court so that this court gets rid of that case law, because it's a shameful case law. So what does it mean, the active phase of war? It means that, like currently, let's say no case can go, let's say not against Russia, but against any state, member of Council of Europe, if it's in the active phase of war, killings, summary killings, executions, etc. So maybe through political window, these changes can be done, not through individual legal process of reforming this international law. Sometimes the problem is within the courts, not within the international codes. And I noticed this by working with different courts, because there are a lot of formalities by which people do not understand, victims do not understand about these formalities, but they lose their cases before these courts.
Thank you so much. And we have a question there. Was the last question, the lady on the first row?
Natalia Gumenyuk, Ukrainian journalist, co-founder of the Reckoning Project, with whom we document war crimes. And we're working with the lawyers from Syria, from where my question is coming from, to all the participants. So having so many, Ukraine is trying to reach out to a lot of countries for support, but a lot of countries are unreachable, in particular those, dictatorship. But we have the support of the civil society and people like you, a lot in this room. So what do you really expect from Ukraine as a state? What could be helpful? Why would be the Nicaragua or Syria or Venezuela? at the same time, Ambassador Korynevych as well, what would be the Ukrainian policy generally, knowing that you won't reach out to Assad or to Nicaraguan president, but there is, you know, the call and there is an openness of a lot of people outside. Would it be Iran or, again, like I can name numbers of the countries? How Ukraine can systematically work and what would be the approach? And also, if we speak also regarding the international venues and law, not just like activist campaign. Thank you.
Thank you so much. So we'll start with you.
Thank you for that question. I think it's a very fundamental question. You need to win this war. And the victory of Ukraine will be the victory of us around the world. I think that you are, as a country, doing the right thing, huge sacrifice. I think that we cannot ask more, but if we could give some ideas, I think that it's important to continue to communicate that this is not a binational issue. It's not a binational conflict. It's actually a global conflict, and the future of Ukraine is deeply linked to the future of global democracy and freedom. And I think if the rest of the world understands that what is happening right now with this invasion of Russia against Ukraine will actually define the global order. And civil society, Ukrainian civil society plays a huge role on that. That's why I devoted some minutes of my presentation to talk about the ecosystem of democracies, because let's face it, legislators will not change anything if they don't feel the political pressure. And this is a pyramid of activism. If we want to reach, let's say, an ambassador, the ambassador receives orders from a minister, and the minister receives orders from a president, and the president wants to be elected or his party wants to be in power, and of course they will only modify their behavior in terms of policy reform or new laws if they feel pressure from the grassroots. So we need to re-empower a grassroots pro-democracy movement around the world. Let me use a very simple example at a scale in terms of disarmament. Anti-personal landmines with the Ottawa Convention were banned through a global civil society movement, as you may recall. It was not states that actually came out with the idea of banning anti-personal landmines. It was a global civil society movement, and it triggered a new mindset in the sense that it proved that it was possible that through global movement, international law can actually be changed. So let's not leave it to the hands of diplomats, into the hands of politicians. We need to create a global ecosystem. And in the concrete and specific case of Ukraine, we need to build a robust, very well organized, international pro-Ukraine movement. And I think that if we come with something very specific out of this conference, not only in the very important issue of Crimea, but in the most comprehensive aspect of the Russian invasion, if we can come with something very specific from this conference, I think that is an initiative of a global pro-democracy movement for Ukraine. And you have the people here that can do that. We have wonderful activists from Africa, from Asia, from Latin America. We're willing to do it, and we can start working right away.
Thank you so much. Anton, will you?
Yeah, just very quickly to the question of Ms. Gumanyuk. I think it's important for us that Ukraine's and our agenda is present everywhere. And I think that it is important that there are people who may support the goal, again, because this is, I'm sure this is the goal of international community as a whole. So I think that this would be maybe not the precise answer you wanted to have, but I think it is important that in this particular case, people may be united by values and principles. And for us, it's important that civil society, expert community in different states, in different regions, they understand the nature of our fight for freedom, for democracy, for human rights, for accountability and justice, and they support us on this track. And so this is maybe how we can work on that. Thank you.
Okay, we don't have much time, so we have just one short question. And
we have a very important question about Armenia.
Thank you very much, distinguished panelists. Nick Urla from Truth Hounds. My question would be to Mr. Ghazaryan. I would like to ask, what is the current perception of Armenians towards the security partnership with the Russian Federation? As you all know, we've been through a quite similar situation where we agreed to give 83% of the Black Sea Fleet of the Soviet Union, which was supposed to be Ukrainian, in exchange of Russian promises that Crimea will be Ukrainian in what was known as the 1997 Big Treaty, the Treaty on Friendship, the Treaty on Black Sea Fleet, and you well know how it ended. The Russians used the very Ukrainian Navy, which should have been, which we gave them as a gesture of goodwill, to launch the war of aggression in 2014. Armenia has a Russian military base. Do Armenians fear that this military base may be used as a base for aggression against Armenia? Thank you.
I don't think that the military base will be a ground for aggression, but will be a ground, of course, for political pressure. But the perception of Armenians is changing, and this ratification of Rome Statute, which Russia classified as an extremely hostile step against Russia, that proves that in my country, people start changing their attitude towards Russia as an ally state, which failed, whether willingly or because being unable to stop military aggression against community of Nagorno-Karabakh, living outside Armenia. So I answer your question. If we're thinking before that military base will be necessary for keeping geopolitical balance in the country and thereby to ensure peace and security in the region. But now that perception is changing because we are looking for other types of international security, and by joining to ICC, that's only one tool. Whether Armenia is going to change its position geopolitically, well, recently we had something that we could never imagine. American troops were doing military exercise in Armenia, not far from the Russian military base. And that also raised real, to say concern, to say nothing, of Russia, including that Armenian First Lady came to Ukraine and met the First Lady of Ukraine. That's also a gesture, political gesture. What would happen after, we don't know, I don't know. But things change in Armenia, and they go very slow, but even in Russia, they started thinking about changing themselves. Like I mentioned, behavior, state behavior. But again, the future is quite uncertain. I hope I answered your question.
Thank you. Thank you very much. We'll have to close, but you can ask your questions during coffee break. For each, do you mind if we take one more question?
Yeah, I just thought that, we've been talking about how to prosecute, leaders who have committed crimes. But I was thinking since yesterday when we heard about abducted children and so on, that can't there be a stronger legal framework? If you have a civil nuclear plant, the IAEA has a right to come and examine your plant. Can't there be a stronger legal framework to allow, international human rights bodies or child rights bodies and so on to step in for victims, irrespective of whether the, guy leading the state is punished or not, just to allow that victims should not lose their lives because, no one can do anything?
Richard, this was a question for you.
Well, I think there are many international organizations that seek to look after people who have been taken as prisoners during war or even during non-war, looking after hostages. And of course, the main organization that's been doing this for many, many decades is the International Committee of the Red Cross. And it does so very quietly, behind closed doors, in a way that really influences bad countries, bad leaders, to allow the International Committee of the Red Cross to send its delegates to visit prisoners, and that's, of course, that's a very important protection, and certainly in my view, all credit must be given to the ICRC in this regard. But of course, it's difficult because autocratic leaders, criminal leaders, are not prepared, certainly not prepared publicly, to allow visits to the people that they are victimizing in their own countries. So we have to do the best we can, but certainly it's a very difficult area and a very important question that has been raised.
Thank you very much. We are closing the discussion. If you have further questions, you can approach our guests during the coffee break. Thank you so much.